Hi, my name's Mariette and I'm a head ombudsman here at the Legal Ombudsman. We investigate complaints about legal service providers, such as solicitors, barristers and licensed conveyancers. We don't take sides and we investigate complaints in a fair and impartial way. If we find there's been poor service, we try and agree a remedy that puts the complainant back in the position they should have been in. Today I'll be talking to you about residential conveyancing. This is one of our largest areas of complaint and has been for a few years now. Between 2017 and 2018, residential conveyancing made up 24% of the cases we dealt with. This is perhaps unsurprising when you consider how many residential transactions take place over a year. If you couple this with the fact that it's a stressful situation and a lot of money involved, this can be one of the reasons why we see so many complaints in this area. For residential conveyancing, the most common type of complaint we see is delay and failure to progress, followed by failure to advise and poor communication. In some cases, a complaint about delay might actually be a complaint about poor communication. For example, if the client hasn't heard anything from their service provider, they might assume that nothing is being done, whereas actually the transaction is progressing quite smoothly. When we see complaints about failure to advise, this is quite often about issues with the property that you might not find out about until sometime later, maybe as many as some years later. In those situations, people bring complaints to us saying that their service provider should have known about the issue with the property and should have told them at the time of purchase. We investigated a complaint where a gentleman had bought a flat on the basis that it had a lovely unobstructed view. After he moved into the property, he found out that there was development work taking place nearby, which would completely obstruct his view of the river. He brought his complaint to us on the basis that the firm should, as part of their inquiries, have found out about this development work and told them about it. We also investigated a complaint from a lady who said that the firm took too long to deal with her, too long to respond to emails, too long to do their inquiries, and too long to deal with the other side. As a result of this delay, her mortgage offer expired and she had to try and get this extended at the last minute. She brought her complaint to us, saying that if the firm had acted more swiftly, she wouldn't have had to run around and get this done in such a panic. In any of the complaints we investigate, we're looking whether the firm provided a reasonable level of service. We're not looking for perfection, but we have to consider whether the service was reasonable in all the circumstances of the case. For example, in a complaint about failure to advise, we would look at whether or not the firm could or should have found out that information prior to a purchase going through. If they did know the information, we'll look and see whether or not they gave their client enough information to make an informed decision before going ahead and buying a property. Remember, it's not the lawyer's job to tell you whether or not to buy a house or whether or not to proceed with the purchase, but we look for them to give you enough information that you know all of your options before you proceed. If we do find poor service, we explain to both parties what we've found and why, and we then look at what remedy would put things right. If we find that the poor service has had an effect, such as increased costs, we may direct that the firm pay these costs, to put you back in the position you should have been in if you'd had a reasonable service. For example, if part of the conveyancing wasn't done right, we might direct that the firm could put that work right for you at no additional cost. Simple, clear communication is a vital part of minimising complaints about residential conveyancing. It's important to remember that whilst technical terms and conveyancing processes may be second nature to you, to your client, they may have no idea what you're talking about. It's also important to remember that whilst a law firm might have hundreds and thousands of clients, to your client buying this house, this is the most important transaction of their life, and they'll expect it to be treated in that way. You can minimise complaints by being really clear with your clients when they should expect to hear back from you, how long it will take you to get back to an email, and what they can expect from the whole process. For more information and guidance on how we deal with complaints and our approach to putting things right, please go to our website. Thank you for watching. Goodbye.